Good afternoon, and welcome to the American Constitution Society's annual Supreme Court preview. I'm Zanelle October, interim president of ACS, the nation's leading progressive legal network, with nearly 250 student and lawyer chapters in almost every state and law school in the country. Through our diverse, rapidly growing nationwide network of progressive lawyers, law students, judges, scholars, advocates, and many others, ACS's mission is to support and advocate for laws and legal systems that strengthen our democratic legitimacy, uphold the rule of law, and realize the promise of equality for all. If you haven't already, I'd encourage you to become a member of ACS and to donate. Our work is more important now than ever, and we need your support. Go to acslaw.org where you can join, donate, and find more information about events like this one. The last Supreme Court term straddled the end of one presidential administration and the beginning of a new one, and the difference couldn't have been starker. For the past 4 years, we have seen the court upend the administrative state by limiting executive power through the adoption of the so-called major questions doctrine and the complete dismantling of Chevron deference. But with a change in administration came a change in the posture of the court's conservative bloc. No longer did the court's conservative supermajority seem worried about executive overreach. Instead, the court repeatedly allowed the Trump administration to pursue its most extreme and unconventional policies, often through rulings on its emergency docket, better known as the shadow docket. These rulings were ostensibly about procedure and process, but make no mistake, through these decisions, the court was undermining the legal and constitutional rights of people living throughout the country. And these shadow docket decisions, essentially greenlighting some of the most harmful Trump policies, were too often unaccompanied by detailed, well-reasoned opinions or really any explanations at all. Lower courts have frequently served as a bulwark, protecting constitutional rights and the separation of powers from this administration's overreach. But without clear guidance from the Supreme Court, they are struggling with how to handle the enormously consequential cases decided through the shadow docket. As one circuit court judge recently noted, the Supreme Court is leaving the circuit courts, the district courts out in limbo. We're out here flailing. For a court already facing a legitimacy crisis, this capitulation without explanation risks harming the court's reputation irrevocably. And in those cases handled through the regular merits docket, we have too often seen the court ignore well-established precedent to achieve the goals of the conservative legal movement. As a result, this court's decisions continue to imperil a person's right to control their own body and access reproductive and gender-affirming health care. It has allowed the First Amendment to be used as a license to discriminate against LGBTQ plus folks and to inject religion into our schools and civic life. It has created a legal regime that protects the most powerful and jeopardizes the health of our democracy. So what does the Supreme Court have in store for us in the coming term? Will these trends continue, or is there hope that the court will uphold the rule of law, honor well-established precedent, and apply the Constitution to protect the rights of the vulnerable, hold the powerful accountable, and restore the delicate balance of separation of powers? To help lead our panel in discussing some of the cases that will determine the answers to these very questions is our moderator for today's preview, and no stranger to ACS, Mark Joseph Stern, senior writer for Slate. Mark covers the courts and the law for Slate Magazine and co-hosts Slate's Amicus podcast. Based in Washington, D.C., he has covered the U.S. Supreme Court, federal appellate and district courts, and state and local courts since 2013. In a crowded field, Mark's insightful legal analysis makes him one of the go-to commentators to provide an understanding of the context and consequences for those cases that grab the headlines and for those that may fall under the radar. We couldn't have a better moderator to lead this incredible group of experts for today's discussion, and I'm so happy to turn things over to Mark.
Thank you so much, Zanelle, for that incredibly generous introduction. I do have a little housekeeping before we dive in. This afternoon's discussion is being recorded, and the recording will be available on ACS's website after the program concludes. For those who want that sweet, sweet CLE credit, information will be available in the chat, and I will be providing 2 CLE codes, one now and one about midway through the panel, so stay tuned. You'll need these codes to confirm your attendance. The first code is, drumroll, HARVEST, HARVEST. Finally, there will be time during today's discussion at the end for audience questions. To submit a question, please use the Q&A box at the bottom of the Zoom screen. And if you're a fellow member of the press, please include the name of your outlets at the beginning of your questions. Now I have the honor of introducing our esteemed panel. I'll do it quickly so we can dive right in. Carlos A. Ball is a professor at Rutgers Law School. Alexis Hoag-Forger is a professor at Brooklyn Law School and co-director of its Center for Criminal Justice. Shobha Sivaprasad Wajia is a professor at Penn State Law and former officer for civil rights and civil liberties at DHS, back when DHS recognized such things. And Pam Carlin is a professor at Stanford Law who previously served as Deputy Assistant Attorney General in the Civil Rights Division of the U.S. Department of Justice. Welcome to all of our panelists. We are going to start with you, Shobha. Could you please kick us off with the shadow docket or merit docket case of your choice?
Thank you, Mark, and grateful to be here. I will start with the merit docket case of Urias Orellana v. Bondi. The issue in this case is whether a Federal Circuit Court of Appeals must defer to a decision by the Board of Immigration Appeals that a set of undisputed facts does not demonstrate mistreatment severe enough to constitute persecution under the immigration statute. The petitioners argue that under the plain text of the immigration statute, prior decisions of the Supreme Court, and bedrock principles of appellate review, Federal Court of Appeals must review de novo whether mistreatment suffered by a non-citizen constitutes persecution. Currently, there is a current circuit split over this question. And to provide a couple definitions, the Board of Immigration Appeals is an administrative appellate body within the Justice Department to which either the government or non-citizen may appeal 30 days after a decision by the immigration judge, also an employee of the Justice Department. Persecution refers to a type of harm. It is an element of the refugee definition, which any person must meet to qualify for asylum. The facts in this case involve petitioners Douglas Humberto Urias Orellana, his wife, and their minor child, all citizens of El Salvador. They fled their country after an extended campaign of terror against their family orchestrated by a sicario, or hitman. There were arguments between the sicario and the petitioner's half-brothers, resulting in 2 half-brothers being shot several times. The petitioner himself received several threats, one by gunpoint, and was also physically assaulted. Douglas moved a few times within El Salvador, but the threats continued. The family fled to the United States. The procedural history is as follows briefly. The family was placed in removal proceedings. That happens after a charging document called the Notice to Appear is filed with the immigration court. The immigration judge found that the threats and assault did not rise to the level of persecution. The Board of Immigration Appeals upheld the immigration judge's decision, and the First Circuit Court of Appeals denied the petition for review, finding that substantial evidence supports the board's no past persecution finding, among other conclusions. Cert was granted on June 30th, and a core question in this case is whether the substantial evidence standard applies or whether review should be de novo. The petitioners make three core arguments in their merits brief. First, they say that under the immigration statute, known as the Immigration and Nationality Act, compared second in complication to the U.S. tax code, courts must exercise independent judgment on what constitutes persecution. They point to a section in the statute called 1252A2D, which directs courts to review constitutional claims and questions of law raised by a petition for review. They further argue that under Loper-Bright, courts were directed to decide legal questions by their own judgment. The petitioners liken the substantial evidence standard to a resurrection of Chevron deference. The second argument made by the petitioners in their merits brief is a reliance on a case called U.S. v. Bank to argue that the standard of review for a mixed question of law and fact in the absence of congressional direction depends on whether the question primarily involves legal or factual work. The petitioners argue that this question, what is persecution, is primarily a legal question and therefore subject to de novo review. Third and finally, the petitioners provide the life and death context consequences of improper deference to the Board of Immigration Appeals. In this case, you have a conclusion by the IJ, immigration judge, you have an affirmance by the board, and then you have a circuit court constrained by substantial evidence review. The petitioners point to the devastating consequences of improper deference and document 138 people murdered after being removed from the United States to El Salvador. Several amicus briefs were also filed in this case. No oral argument date has been set. The next case is an emergency docket case called Nome v. Vasquez v. Perdomo. The question before the court was whether the Supreme Court should stay a district court order preventing federal immigration officers from relying on any combination of four factors: race or ethnicity, speaking Spanish or accented English, presence at a location and working specific jobs, such as landscaping or construction, to justify conducting detentive stops. A federal district court judge issued a 52-page decision and a temporary restraining order, blocking the government from conducting detentive stops without the legally required reasonable suspicion, and in turn from solely relying on one of these four factors. The district court is contained with a significant factual record and plaintiff stories, including one U.S. citizen who was in a tow yard in Los Angeles, who saw Border Patrol agents carrying handguns, including two with military-style rifles. When this U.S. citizen told the agent multiple times that he was American, he was asked, "What hospital were you born in?" He calmly responded more than once he did not know. Agents pushed him against a metal-gated fence, put his hands behind his back and twisted his arm, took his phone and real ID, eventually returning the phone, but not the ID. The government appealed to the Ninth Circuit. The Ninth Circuit upheld the TRO. The government filed an application for an emergency stay with the Supreme Court, and on September 8th, the court granted the stay by a decision of 6-3. There was no opinion on the merits or reasoning by the majority of justices. Justice Kavanaugh wrote a concurrence of 1, concluding that the government would likely prevail. And then we saw a dissent by Justice Sonia Sotomayor, along with Justices Kagan and Jackson, calling the majority's decision, quote, "an other grave misuse of the emergency docket," end quote, and with the following prelude, quote, "We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job. Rather than stand idly by while our constitutional freedoms are lost, I dissent," end quote. There's been a lot of reaction to this case. Critics have called this outcome one that legalizes racial profiling and creates novel interpretation of the reasonable suspicion doctrine. In my own spaces, I've received so many questions from community members, students, faculty, with questions like, oh, this means I can be stopped on my way to work, or I am going to ask my spouse to carry his passport each time he leaves the house. There is a real concern that this decision will more broadly normalize immigration enforcement based on how a person looks, what language they speak, or where they work, and no other factor. Some argue that this is also a departure from a seminal decision by the Supreme Court in 1975 that found use of roving patrols to stop cars based solely on appearance of Mexican ancestry violates the Constitution. So what happens next will depend on whether cert is granted or we see a decision on the merits. Stay tuned. Thank you.
Thank you, Shobha. So you mentioned that Justice Kavanaugh wrote a concurrence of one. I just want to read a sentence from that concurrence and ask for your reaction. Kavanaugh wrote to describe what ICE is doing on the ground, quote, immigration officers briefly stop an individual and inquire about immigration status. If the person is a US citizen or otherwise lawfully in the United States, that individual will be free to go after the brief encounter. Shobha, is that an accurate reflection of the factual record in this case?
Not necessarily. There is a space between the excerpt you just shared and the declarations and the evidence that was presented and utilized by the federal district court to reach its conclusion that use of these four factors, and these plaintiffs did include US citizens, fall outside reasonable suspicion.
Do any of our other panelists have follow-up questions?
I don't have a follow-up question necessarily, but I do think it's interesting as I'm hearing Shobha speak. I'm going to be talking in a few minutes about some LGBTQ cases, in which it seems to me the court in the last several years has expressed great skepticism of governmental overreach in the enforcement of laws that are intended to protect LGBTQ people from harms. So just to give one example, in 303 Creative versus Alenis, the court told us last year that Colorado in that case was only seeking to enforce the anti-discrimination law in order to purportedly force a conservative business owner to speak in a way that she didn't want to speak. That's governmental overreach, violates the First Amendment. And yet, in a case like Perdomo, when we have law enforcement officers stopping people because of the color of their skin or the language they speak or the neighborhood in which they live in, there seems to be absolutely no concern about this from the same court about governmental overreach. So, you know, the rule seems to be that the government under Republican control can be trusted, but a government under Democratic control cannot, which is obviously not a rule of law, not a legal principle, but it shows how the court is, in my view, losing its legitimacy because whatever perception of neutrality it might have enjoyed prior to the last few months, it is losing it in cases like Perdomo.
That's such a good point. You know, Shobha, you mentioned that the majority didn't actually write a decision. All we have is this one concurrence. I'm curious if you or any other panelists have any guesses as to why the majority didn't bother to explain itself. You know, this is a recurring feature of the shadow docket. I think we'll probably talk about it again. It would seem that if the court is going to greenlight racial profiling and ICE enforcement, it would at least bother to give us some reason why, but it didn't here. Do any of our panelists have any idea of why that might be?
I mean, to your point, Mark, it's an emblem, right, of these shadow or emergency docket decisions that are not truly decisions. And so we are also seeing a lot of discretion being utilized by the court itself on when it would like to pontificate on their grant or partial stay and when they do not.
a very stark contrast to how rarely the same court intervened to rule in favor of President Biden on the shadow docket, I must note. They seem to be leaping to help Trump in ways that they were not doing with the previous president.
And there were virtually no cases on the shadow docket. I mean, Donald Trump has taken more cases up in the first, what is it now, 9 months or 10 months of his administration than the Biden administration took up in its entire time, I think.
Okay, thank you so much, Shobha. Moving on to Alexis, will you please tell us about Villarreal v. Texas and Ham v. Smith?
Great, thank you, Mark. David Visa or Asa Villarreal versus Texas. We're going to hear from the parties and the court next week. So it's an October 6th oral argument. And it's on direct appeal from the state of Texas. And their high court there is the Texas Criminal Court of Appeals. And the question presented is when a trial court takes an overnight recess while a criminal defendant is testifying, may the court prohibit defense counsel and the defendant from discussing defendant's ongoing testimony? So this is looking directly at the Sixth Amendment right to counsel. Just to back up a little bit, Mr. Villarreal was charged with the stabbing murder of a known person. It was a romantic partner. He claimed he was acting in self-defense. So the trial's in 2018. On day 3 of the trial, we're in defense's case in chief, and Villarreal testifies. Those of us that represent people facing criminal charges know it's extremely rare for a defendant to take the witness stand. And when that does happen, it's typically because the defendant is alleging self-defense, and the jury will want to hear the defendant's side of the story. So Villarreal is up, he's testifying. In the middle of his testimony on direct examination, the trial court schedules an sort of a pre-planned overnight recess, and there's going to be a break for a full 24 hours. Courts have lots of discretion. They have, a very active docket at the trial level, and so they may need to take a break from one case that's at trial to attend to other matters. So this is all pre-planned. As the court is sort of closing for the day, excuses the jurors, it gives an order to Mr. Villarreal's defense counsel and says that you cannot speak to the defendant about his ongoing testimony, says you can speak about other things, but recommends to defense counsel that he should treat this overnight recess as though Mr. Villarreal is still on the witness stand. In the transcript, there's a little bit of ambiguity. Defense counsel's sort of confused. Can I talk about defense strategy if it's also about Villarreal's testimony? And so we get some ambiguity. Parties return the next day, trial proceeds. Mr. Villarreal is convicted because of some sentencing enhancements. He's sentenced to 60 years in prison, and he appeals. So the Texas Criminal Court of Appeals, which again is the high court in the state of Texas for crim cases, they focused on the type of communication being restricted, sort of ignored the length of the recess, which was a full 24 hours. And they sort of ignored that it was during a critical stage of trial, which was Mr. Villarreal's testimony. And they also were concerned that defense counsel may have been trying to, steer defendant's testimony, that there was the potential for that. And so then decided, okay, the trial court's order prohibiting contact was reasonable. Also sort of ignored some of the ethical rules that all defense counsel have to adhere to. So the dissent, which is from Judge Walker, again, this is the Texas Criminal Court of Appeals, said the entirety of Villarreal's case here depended on his testimony of self-defense. And that the trial court's order prevented him from conferring with defense counsel about all sorts of defensive matters, which were inextricably intertwined with his ongoing testimony on direct examination. This included the events directly leading up to the incident, the verbal and physical altercation between Mr. Villarreal and his partner, and some of the defensive wounds he'd sustained. The dissent also noted that the court's order was ambiguous and found that problematic. So the Supreme Court has repeatedly held for several decades that the Sixth Amendment requires that the accused have meaningful access to effective assistance of counsel during all critical stages of criminal proceedings. And I'm sort of collapsing a few SCOTUS decisions there. It also recognized that, yes, trial courts have broad discretion to limit witness communication before, during, and after testimony to limit witness tampering. However, what's critical here is that Villarreal isn't a typical witness. He's a party, he's the defendant, he's an accused person, and he has all of these rights, including the Sixth Amendment right to counsel. Thankfully, there are two prior opinions from SCOTUS that deal with this issue, not the exact facts, but provide some really great guidance. So Getters versus United States, it's a 1976 opinion, 8-0. And they held that a recess during defendant's testimony between direct and cross, so very similar to what's happening with Villarreal, court order prohibiting the defendant from discussing anything with counsel violated the Sixth Amendment right to counsel. So here we have a difference. In Geddes, the trial court said you can't talk about anything over a 17-hour recess. Villarreal, we have you can't talk about defendant's testimony during this 24-hour recess. 13 years later, the court decides Perry versus Keek. It's a 1989 opinion, 6-3. And the court's no discussion order during a very brief 15-minute recess in defendant's testimony does not violate the Sixth Amendment. So here we have a pretty big difference in terms of the temporal length of the recess, 15 minutes versus 24 hours. And again, to my knowledge, Perry did not involve sort of this self-defense theory. So I think as we take a look at how the court might decide, an overnight recess typically is pretty crucial for a defendant and a counsel to strategize, to make tactical decisions. And the court made this observation in Perry, that's the 1989 opinion, that consultation between the defendant and counsel can encompass matters that go way beyond just the defendant's testimony. They could be speaking about the availability maybe of other witnesses, again, sort of tactics. Maybe they're even talking about a possible plea negotiation, which can happen, during the course of trial, depending on how things are going. And that such discussions inevitably will touch upon something that the defendant is testifying about. Again, this is from SCOTUS's decision in 1989, so they're giving us some signaling. And I think at the heart of this is that, does the Sixth Amendment right to counsel trump concerns about potential coaching during a long recess? I mean, that was sort of the stated rationale of the trial judge here. I had the opportunity when I was in residence at the Constitutional Accountability Center to co-author an amicus brief on this case. I'm eager to hear how the court decides. I do think that if the court sides with Villarreal, that his Sixth Amendment right to counsel was violated, it will be very narrowly tailored to the specific facts of this case.
Thank you. Before we move on to Ham, there's a lot there. I'm just curious if you want to wager a guess as to how the court will rule in this case. The court doesn't take that many Sixth Amendment cases. It's a little sort of surprising. We have this case on the table. What do you think is going to happen?
Yeah, I mean, I think everyone, beginning with the trial court on down the line, was very aware of these two prior SCOTUS decisions dealing with factually analogous but not right on point situations. And so I think the court's going to want to provide some clarity, given that this is a much longer recess than we saw with the 15-minute decision, and then the subject matter. So defendant's ongoing testimony, well, they're giving their self-defense sort of theory of the case. I'm inclined to believe that the court will rule for the defendant here, and again, really stick to the facts, which is that this was a self-defense case, and that inevitably, when a defendant is asserting self-defense, their testimony is central.
Okay, thank you. Do any of our other panelists have thoughts on Villarreal before we move on to Ham, or the court's broader treatment of criminal procedure?
Well, now you're opening up a whole can of worms when we go to criminal procedure.
Okay, well then we'll wait and you can move on to Ham.
Great.
Please,
So,
go ahead.
Yeah, Ham versus Smith is a case that originates out of Alabama. John Q. Ham is the commissioner of the Alabama Department of Corrections, and Joseph Clifton Smith is the convicted person who had been sentenced to death. This argument already scheduled. It'll happen on November 4th. John Smith was sentenced to death for a murder in 1997. The facts, the details of the murder, the conviction, not at issue. What we're focused on is whether and how courts may consider this cumulative effect of multiple IQ scores in assessing an Atkins claim. And what's slightly unusual, maybe nothing is unusual anymore, but SCOTUS crafted their own question presented here. It's not exactly what the parties had raised in their briefing. And here we have the defendant actually winning below at the 11th Circuit. I also want to point out how unusual that is. First, that a defendant wins at the 11th Circuit, but also we have the essentially the losing party, which is the state, the Department of Corrections, the commissioner seeking cert, which is typically not a good thing for those concerned with the procedural protections in place for accused people. So Atkins is the case referenced in this question presented. Atkins versus Virginia is a 2002 decision, and it made clear that the Eighth Amendment, the clause dealing with cruel and unusual punishments, it prohibits the execution of people with intellectual disability. I'll abbreviate that as ID, because they are less culpable, not able to understand the wrongfulness of their actions, the seriousness of the charges, or even the gravity of the punishment that they face. Atkins, the court there noted that intellectual disability typically, and I'm using quotes there, applies to people with an IQ of, I quote, approximately 70 or lower. And it really left it up to the states to decide how it is that you diagnose or define intellectual disability. The key takeaway, though, is that there is no penological purpose served by executing people with ID. So something that all the parties agree on is that the diagnostic criteria for intellectual disability requires three things. And this is something that the clinical community, the psychiatrists, psychologists all agree upon. One is substantially sub-average intellectual functioning, which is often an IQ score. Two is significant deficits in adaptive behavior. And three is that the onset, it was onset during the developmental years, so under the age of 18. As someone who represented people in post-conviction who were capitally sentenced, there's often not an IQ score, or rather an ID diagnosis prior to their contact with the criminal legal system. And so it's often something that we're trying to figure out retroactively. And again, it's key that the diagnosis could have been possible between 0 to 18 years old. So you're looking often at old records, old documents, old tests, and you're relying on the assessments that were made sometimes 30, 40, 50 years ago. So it does require both qualitative and quantitative measures. People with IQ scores over 70 can still be intellectually disabled based on their adaptive functioning deficits. And it is a lifelong neurodevelopmental condition. It's not something that someone just springs forward with. I mentioned adaptive deficits. I think it's important to note that has to do with communication, interpersonal communication, decision-making, self-care. And there's no one single piece of evidence, such as an IQ score, that is conclusive for intellectual disability. So Mr. Smith had 5 IQ scores during his developmental years, and they range from 72 to 78. There is a standard error of measurement, and given that standard error of measurement, we can see that Mr. Smith would have an IQ score that falls below 70. In post-conviction, the Alabama Court of Criminal Appeals affirmed that Smith was not intellectually disabled, but then a federal district court years later held an evidentiary hearing, credited Smith's experts, and said, you can't determine intellectual disability based on an IQ score alone. You have to consider this additional relevant evidence of intellectual functioning. So the expert there looked at the behavioral history, his school records, and other assessment tests, not necessarily just IQ, and found, yes, in fact, Smith is intellectually disabled and his execution would violate the Eighth Amendment. This is also very rare for a federal district court to make this finding. And then in 2023, the 11th Circuit affirmed the district court's finding that his execution would violate the Eighth Amendment because he's intellectually disabled. Also, very rare for the 11th Circuit, given its composition, to affirm this kind of decision. SCOTUS has relisted this case several times over the last 10 months. They even remanded it back to the 11th Circuit, asking the court whether sort of a single standard error rule based on the lowest IQ score or this holistic approach, sort of more comprehensive assessment, is the way to go. 11th Circuit said we use a holistic approach. That's what the SCOTUS precedent tells us to do. There's a case from 2014 from Florida, Hall versus Florida, which held that intellectual disability, it's a condition, it's not a number. You can't just focus on IQ scores. There is deep disagreement among the justices on how to navigate these issues. Chief Justice Roberts, Thomas, Alito, they all dissented in Hall. Thomas, who was on the court in 2002 when they decided Atkins, was the dissent there. The petitioner, who is our commissioner in the Department of Corrections, said that there should be a categorical score-based rule focusing on IQ scores. Again, that's not where the clinical standards are. And Smith says it should be based on a totality of the evidence and that courts should look at other areas of defendants' intellectual functioning. It's common rather for their defendant to have fluctuating tests. Also, once a defendant is in the criminal legal system, they're often assessed multiple times. Sometimes you can have someone taking an old test and the population gets smarter, so they need to be renormed. So the fact that Smith has multiple scores that do vary shouldn't disqualify him from a diagnosis. And the courts really should be considering intellectual disability the way they should be relying on the clinical standards here. Courts are not in a good position. We saw with Texas and the Briseno factors, they based it on, I think it was Steinbeck's Of Mice and Men, sort of what intellectual disability looks like based on a fictional character, Lenny. And so thankfully, the Supreme Court in this series of cases is saying that, hey, courts should look to what clinicians say. And so we've got a lot of amicus support from those bodies, the American Psychological Association, the American Psychiatrics Association. If I have a little bit more time, I can just briefly mention that there are about 15 other crim cases so far on the docket.
Wow. Okay. Thank you. I hope we have a chance to get to those. I just want to briefly ask you same question from before. How do you think the court will decide this? You mentioned that the Republican appointed justices are skeptical of Eighth Amendment restrictions on capital punishment, especially for intellectually disabled people. Do you have any optimism that this case will be affirmed, that the 11th Circuit decision in favor of the defendant will stand?
It's hard. I mean, Alabama law says it has to be proven by a preponderance of the evidence. That test is not at issue necessarily, but I don't think courts, our court, as it's currently composed, doesn't really like to weigh in on how states should figure out these details. And so the fact they can point to Atkins and say, hey, we've already said that you can't execute people with intellectual disability, and then states figure out if someone is intellectually disabled. I would like to think that the court will side with this holistic evaluation, but I'm not as sure with him.
Yeah.
Can I just ask a question here, which is, doesn't the fact that they've relisted it this many times suggest that what's really going on is a question about whether they can get 6 votes to summarily reverse rather than take the case?
I certainly hope so, Pam. And it's, we read tea leaves a lot. And I think that's a really good tea leaf reading of what's happening. I mean, it is unusual. There's a lot of unusual things about this case, and one of them is, as Pam reiterated, is the relisting.
All right. Thank you, Alexis. Let's move on now, in the interest of time, to Carlos, who is going to tell us first about Childs v. Salazar.
Okay, thank you, Mark. Yeah, so Childs v. Salazar involves a free speech challenge to Colorado's ban on so-called conversion therapies. Colorado is one of about 25 states that prohibits licensed healthcare professionals from attempting or purporting to change a minor's sexual orientation or gender identity. Studies show, and have shown for quite a long time, that conversion practices harm minors who are often forced by their families to participate. The history of conversion therapies is an extremely ugly one. During the 20th century, doctors subjected LGBTQ people to electroshock and chemical treatments. Contemporary defenders of conversion practices, however, insist that they only want to provide so-called talk therapies to their patients, which really makes up the gist of the constitutional challenge to Colorado's law. The petitioner, Ms. Childs, is a licensed counselor. According to her cert petition, she is, quote, a practicing Christian who believes that people flourish when they live consistently with God's design, including their biological sex. It's important to know that the state has not sought to revoke Ms. Childs' license. In fact, Colorado has never moved to revoke anyone's license for engaging in conversion therapies. But Ms. Childs has brought a pre-enforcement challenge, arguing that the therapy ban is a content and viewpoint-based restriction on speech, and she's asking the court to apply strict scrutiny and to strike the law down. There's been quite a bit of First Amendment litigation involving conversion therapy bans. The Third and Ninth Circuits have rejected the challenges, but the 11th Circuit has struck one of these laws down. Last year, the 10th Circuit in Childs upheld the Colorado law after concluding that it regulates professional conduct rather than speech, and that therefore rational basis review applies. Although I think that's a reasonable and defensible holding, I also think it's unlikely that the court will only apply rational basis review in Childs. In the 2018 case of Nifla versus Becerra, Justice Thomas, in writing for the court, went out of his way to reject the claim that only rational basis review applies to regulations of professional speech. Now, there are ways of distinguishing Nifla from Childs, but I worry that the court will not find those persuasive. A more promising ruling, perhaps, for Colorado may be another of Justice Thomas's First Amendment opinions, Free Speech Coalition versus Paxton, which was issued this past year. In that case, the court rejected a First Amendment challenge to a Texas law requiring sexually explicit websites to implement age verification measures. There are significant similarities between the laws challenged in Free Speech Coalition and in Childs. The state in both instances is exercising its police power authority to protect minors from harm. The intent of both laws is to avoid that harm, right? The purpose of neither is to censor or to chill speech. Whatever effects the laws have on speech, they are incidental, and therefore, under the reasoning of Free Speech Coalition, intermediate scrutiny rather than strict scrutiny should apply to Ms. Childs' case. The court applied intermediate scrutiny in Free Speech Coalition in ways that were very differential to the government's interest in protecting minors. I think that same deference should apply in Childs. And we should remember, while thinking about this, that intermediate scrutiny under the First Amendment is not as rigorous as intermediate scrutiny under the Equal Protection Clause. In fact, the government routinely wins when courts apply intermediate scrutiny in free speech cases. Colorado not only has a compelling interest in protecting minors from harm, it also has a substantial interest in making sure that medical professionals abide by standards of care. The state should be able to enforce those standards even when they implicate a medical provider's speaking to patients. State law, for example, governs informed consent requirements regulating medical professionals' speech with patients. Surely, however, doctors don't have a First Amendment right to say whatever they want when getting a patient's informed consent. So I think that if the court applies intermediate scrutiny, Colorado should win. But I think the court will instead apply strict scrutiny and strike down the statute. And my pessimism mainly derives from the sheer number of cases, now going back 30 years, in which the court has used the First Amendment to limit the government's ability to protect LGBTQ people from harms. In this line of cases, for example, the court granted the Boy Scouts a First Amendment right to discriminate against gay men, sided with the baker who refused to serve same-sex couples in Masterpiece Cake Shop, granted Catholic Social Services in Fulton versus Philadelphia a constitutional right to a government contract. I'll repeat that. A constitutional right to a government contract, even though the Catholic agency refused to provide foster care services to gay families. And most recently, as I mentioned earlier, the court granted the business owner in 303 Creative a First Amendment right to refuse to provide same-sex couples with the same business services that she was willing to offer to heterosexual couples. So this is a court that is literally tripping over itself, legal doctrine be damned, to void governmental efforts protecting LGBTQ people from harm. I don't think the court will account for the harms caused by conversion therapies, in part because, like 303 Creative, Childs versus Salazar is a pre-enforcement action. So we don't actually have minors who've been harmed by a therapist in this case. Instead, the only claim of harm is by an identifiable human being, is the therapist's claim that the law silences her professional work. I worry that the court will deem the law to be a content and viewpoint-based regulation because it allows talk therapies that help LGBTQ minors to live according to their sexual orientation or gender identity, but not talk therapies intended to change those identities. And I think the court will say that the evidence of harm to children from the therapies is insufficient to justify the viewpoint-based regulation.
So I have a quick question, but first I have an important housekeeping announcement, which is that it's time to provide the second CLE code. The word is cider, C-Y-D-E-R, very seasonally appropriate, which I appreciate. And I'm just going to remind people to submit their questions using the Q&A button at the bottom. So, Carlos, I wanted to ask, it seems like the overwhelming majority of briefs in favor of the counselor, including her own brief, the Justice Department's brief, which is weighing in on her side, and the amicus briefs, focus far more on gender identity than sexual orientation. There is a massive focus on, basically targeting trans kids, saying that they actually need conversion therapy because being trans is somehow bad. And then a kind of like an intentional disregard for gay children's sexual orientation, almost as if the petitioner side knows that it's more politically popular to target trans people than gay people. Do you think that that is a fair read of the dynamic that's going on here? And do you think that's what the Supreme Court will mirror back?
Absolutely. Unfortunately, yes, that is absolutely true of the briefs. And I have to say, it's absolutely true of the wider political discourse. The Trump administration and the Department of Justice as part of the Trump administration have really focused on the transgender issues, right? That's where they smell blood. That's where they think they can make their political points and their political gains. They are ignoring lesbians, gay men, and bisexuals for the most part. Though, you know, they did take away the Harvey Milk name from that battleship. But and it's really interesting that you see that strategy reflected in legal briefs as well. You know, the Supreme Court's decision last summer in Scrimetti, you know, was an equal protection challenge. This is a First Amendment one, you know, very, very different apples and oranges, but absolutely, I think the administration, the plaintiff's attorneys, and their amicus allies are very much counting on that kind of really fear of transgender issues and purported concerns for transgender children, right? I think that's very much part of what's going on here, and I worry, you know, it will be reflected in the court's ultimate opinion. Yes.
So I think that's a good segue now to the next case you're going to tell us about, which is West Virginia versus BPJ.
Sure. Yeah, sure. So yeah, so issues of harm, interestingly enough, to children are also at the center of the second case. At least, you know, this time, according to as well to the state. The West Virginia versus BPJ involves a state statute mandating that only, quote, biological females be allowed to participate in school-sponsored female sports. The lawsuit was filed by an 11-year-old sixth grader with the help of her mother. BPJ wanted to join her middle school's girls running team, but the principal prohibited her from doing so, relying on a West Virginia law that bars her from competing against other girls because she was assigned male at birth. BPJ is now 14 years old. She's been taking puberty blockers for several years, and so testosterone has not physically changed her body. She is not challenging the statute facially. Instead, she brought an as-applied challenge under the Equal Protection Clause and under Title IX. If she wins and gets a permanent injunction, the remedy will apply only to her. There is, by the way, a second case before the court challenging a transgender athletic ban enacted by Idaho. But the plaintiff in that case earlier this month withdrew her lawsuit, and that case is likely to be dismissed as moot, though the state is fighting that at the moment. The Fourth Circuit in BPJ's case granted her summary judgment on the Title IX claim, but it denied summary judgment for both sides on the equal protection issue and remanded to determine whether those who were assigned male at birth, but who haven't gone through puberty, whether they have meaningful athletic advantages over those assigned female at birth. In upholding the transgender healthcare bans in Scrimetti this past summer, the court concluded that those laws do not classify on the basis of either sex or transgender status. I disagree with that holding, but there is an argument to be made that the healthcare bans are sex neutral because they apply equally to boys and girls. But you can't make that argument in the BPJ case because the West Virginia statute treats girls differently than boys. The law excludes transgender girls and women from female competitions, but doesn't exclude anyone from male sports. That is a clear differential treatment on the basis of sex that requires the application of intermediate scrutiny under the Equal Protection Clause. I don't know, therefore, how one logically gets around heightened scrutiny, though this court may very well try. But I think the bigger problem for equal protection law, ironically enough, may come if the court does the doctrinally correct thing and applies intermediate scrutiny. Because I think the danger is that the court, after applying intermediate scrutiny, will then proceed to uphold the constitutionality of the law, reasoning that it is not grounded in gender stereotypes, but is instead based on physical and so-called enduring differences between men and women. And so I fear that we may end up on the gender equality front with a ruling upholding the differential treatment of men and women, based on purported intrinsic differences between the two, which would obviously not be a good outcome from a progressive and feminist perspective. What about on the transgender rights front? Well, it's possible, I suppose, that the court will conclude that laws like West Virginia's do not classify on the basis of transgender status, in the same way that it somehow concluded in Scrimeti this past summer that transgender healthcare bans are neutral on gender identity. Now, that would be entirely illogical in my view, because the evidence is overwhelming that the purpose and effect of the West Virginia statute in BPJ is to exclude transgender girls and women from female sports. But the bigger problem, once again, may come from the court doing the doctrinally correct thing by holding that the statute classifies on the basis of transgender status. 3 justices, Barrett, Thomas, and Alito, already told us in Scrimeti in concurrences that they don't think that transgender classifications are quasi-suspect. I don't see how we get to 5 votes on that question. And I think, therefore, that the worst possible outcome in BPJ would be for the court to uphold the statute after holding the gender identity classifications merit only rational basis review. I think this would make it significantly more difficult to challenge the hundreds of anti-transgender laws enacted since 2020. And it may also lead courts to uphold the administration's outrageous transgender military exclusion policy. Lower courts that have rejected the equal protection claims in transgender student cases have also rejected the Title IX claim. And the Supreme Court may follow suit by reasoning that Title IX allows for the legally mandated separation of male and female athletes when they are competing, and that biological sex matters when it comes to sports. Well, BPJ is a girl, and she argues that she's ultimately similarly situated to other girls. I worry that the court will view her as a boy for purposes of athletics and conclude that she's not similarly situated to other girls and therefore can be excluded from female sports without violating Title IX. I'll finish by apologizing for my pessimistic tone, but I think we do need to be clear-eyed about the fact that whatever legal protections are forthcoming for LGBTQ people in the years to come, they are unlikely to originate with the Supreme Court. The court is very likely to continue issuing rulings that either strike down laws protecting LGBTQ people from harm, as in Childs, or upholding laws that harm them, as in the BPJ case, which really, of course, perfectly track the policy preferences of the Republican Party. At the same time, I think we will ultimately prevail on these issues. It may take a few years, but I think we as a society will eventually look back at cases like BPJ and shake our heads at the sheer injustice and cruelty of enacting laws to exclude 11-year-old girls from the middle school athletic teams.
Thank you so much. I know that we all probably have a lot of thoughts about those cases, but we're running a little bit behind. And so I just want to make sure before we move to discussion that we get Pam's cases in as well, because they're also so important. So Pam, last, certainly not least, could you please tell us about the 2 Voting Rights Act cases this term, Louisiana v. Calais and Turtle Mountain Band v. Howe?
Yeah, so it's great to be here. I'm actually going to talk about 3 cases, but in the same amount of time. So let me start with Louisiana against Calais, which is a case about whether Louisiana has to draw a second majority Black opportunity district, or more formally, does Louisiana have to draw a second congressional district from which Black voters in the state, who make up about 1/3 of the population, can elect their candidate of choice? There was a case called Robinson against Ardoin, in which a district court found that Louisiana had violated the Voting Rights Act by failing to draw a second district that would give Black voters a chance to elect a candidate of their choice. 2 unanimous panels of the Fifth Circuit agreed with that. And so Louisiana drew a new map that created 2 majority Black districts. But in drawing that map, they really wanted to protect Mike Johnson's seat, Steve Scalise's seat, and another seat. And so they draw a district that's sometimes referred to as the slash district, because it goes through the state like that. And a group of voters who identified themselves as non-Black voters, that's what they claimed in their complaint, filed suit claiming that the new map was a racial gerrymander and therefore violated what's sometimes referred to as the Shaw Doctrine, a doctrine that essentially says that race can't be the predominant factor in drawing districts. The Supreme Court noted probable jurisdiction in that case because that issue is an issue that the Supreme Court has mandatory jurisdiction over, as opposed to the discretionary jurisdiction that exists with regard to all the cases we've been discussing up till now. Heard oral argument last term, and on the last day of the term announced that it would hear re-argument in the case. It then set the case for re-argument. It's going to be argued the second week of the October sitting on October 15th. And directed the parties essentially to brief the question whether creation of a second majority Black district in Louisiana would violate the Constitution. That's the issue that's been briefed. A couple of interesting observations about the case. One is that the United States has switched sides in the case. Originally, the United States was defending Section 2 of the Voting Rights Act and saying that Section 2 and the liability under Section 2 created a compelling reason for the state to draw a second majority Black district. Last week, the government filed a brief essentially suggesting that if Section 2 does anything more than really smoke out purposeful, intentional racial dilution, it violates the Constitution, and that it requires too much race consciousness, that the time for what it thinks of, the government now thinks of as affirmative action in voting, is over. I don't think the case is about affirmative action at all. I think the case is about giving every voter a fair opportunity to elect candidates of their choice. And we'll see how this comes out. The state of Louisiana has also switched sides since its earlier brief. Its earlier brief said, let us draw a second majority Black district this way to fulfill our political goals as well. Now the state has come back in and said, no, it was unconstitutional for us to draw these districts, sort of the, killing your parents and then claiming you're an orphan defense. So that's where Louisiana against Calais is. My guess is that the Supreme Court is not going to come right out and declare Section 2 of the Voting Rights Act unconstitutional, but I think the court may try to tighten up a little bit what kind of remedy you get in a Section 2 case, and maybe even how you prove liability in a Section 2 case. But this all might not matter at all if the Supreme Court grants certiorari and then decides a case called Turtle Band of Chippewa Indians against Howe the wrong way. So since the creation of the Voting Rights Act in 1965, voters who have been denied their rights under the Act have filed lawsuits challenging state action. They filed these lawsuits under Section 5 of the Voting Rights Act, and the Supreme Court recognized a private right of action there in a case called Allen against State Board in 1969. They filed suits under Section 10 of the Voting Rights Act about poll taxes, and in a case called Morse against Republican Party of Virginia, the Supreme Court recognized that. The Supreme Court has decided, I think, 24 Section 2 cases brought by individual voters or groups of voters. And in all of those cases, it has been an implied right of action. The Eighth Circuit held a couple of years ago that there was no implied right of action under the Voting Rights Act. And you might think, well, that doesn't necessarily matter that much because Section 1983 gives individuals an express cause of action when they've been deprived of a right secured by the Constitution and laws of the United States. But the Eighth Circuit held in the Turtle Band case that Section 1983 doesn't even create an express right of action here. The Supreme Court stayed the Eighth Circuit's mandate, which would have ended up tossing out a state legislative district drawn for the Chippewa Band in the North Dakota legislature, but 3 justices dissented from the grant of a stay on the mandate there. So my guess is the Supreme Court will take this case, but honestly, I find it hard to believe that the Supreme Court would hold that voters who have been denied their rights under Section 2 of the Voting Rights Act cannot bring suit at all. So I'm pretty optimistic that the court will both take this case and hold one way or another that there is a right of action. This is particularly critical because the Voting Rights Act has been completely abandoned by the Justice Department, which has gutted the voting section and is taking a very hostile approach. Last case I want to mention very briefly is a case called Bost against Illinois State Board of Elections, which is going to be argued on October 8th. This is a case that could be extraordinarily important as a practical matter. So lots of states, most voters now do not vote on election day. They either vote early in early voting centers or they vote by mail. And in some states, the majority of voters are voting by mail. Many states, indeed a majority of the states that allow vote by mail, have a rule that says your mail-in ballot has to be postmarked by election day, but it can arrive several days after that and still be counted. Bost is a case challenging Illinois' rule that allows these ballots that are sent by election day but not received until after election day to be counted. And the question here is whether the question on which the Supreme Court's granted certiorari is whether Bost even has standing to challenge this Illinois rule. He's a candidate for election. But a Fifth Circuit case that's a follow-on to this, that's pending, that there's a cert petition pending on, Walker against RNC, is really quite critical because the Fifth Circuit held that at least as to candidates for federal office, which means senators, representatives, and electors in the Electoral College, Mississippi cannot count those ballots if they arrive after Election Day, even though Mississippi law says you have 7 days to do this. And I think this question is extraordinarily important because voters now understand the rule, which is get your ballot, send it back, and do it by election day. But if you change that rule so the ballot has to arrive by then, it's totally unclear to voters exactly when they have to cast their ballots. Because I would wager most people have no idea what is the longest amount of time it will take to get from my post office to the Board of Elections or the like. And so this is a really critical issue because this is how most Americans now vote.
Thank you, Pam. I will just note that I think that the Fifth Circuit's decision on late arriving ballots is one of the most incoherent and poorly reasoned appeals court decisions that I've come across in my entire career. And
well, I think it's an auditioning for the next seat on the Supreme Court opinion.
Indeed, it was an opinion written by Judge Andy Oldham on the Fifth Circuit, who seems gunning for the Alito seat should it open up. But Bost, I think, may give us a glimpse into how the justices are thinking about this issue, even though it's only a standing case, as you say. Staying with you, Pam, I want to pivot to a sort of bigger picture look in the time that we have left before we get to Q&A. Just one more reminder to put those questions in the Q&A box at the bottom. We've talked a bit about this already. The court has been accelerating its use of the shadow docket. The Trump administration has been leaning on the court to overrule lower courts that stand in its way through the shadow docket. Already, as this discussion has shown, the justices have teed up a bunch of big blockbuster cases, culture war cases, separation of powers cases. How do you see the coming term playing out? Do you think that this is going to be another kind of wipeout for progressives where the court aggressively pursues its agenda? Do you think that the court is going to step up and stand up to Trump at all? What do you think is going to happen?
So, I mean, we didn't talk about it in our initial, but the court is gunning for getting rid of Humphrey's executor. I mean, I think of the current court as Humphrey's executioner instead of the executor. And that will gut independent agencies. The court has been dodging the substance, at least so far, of an awful lot of Trump administration acts, but those things are coming back to them. The Solicitor General has now asked for certiorari on the actual merits of the birthright citizenship order and like. And so, you know, the Supreme Court has to stop acting as if we are facing a normal administration doing normal things. And whether they're going to do that or not is anybody's guess. You know, the Supreme Court is, as Alexander Hamilton said, the least dangerous branch because it doesn't have a lot of power. It has to rely on the executive and legislative branches to instantiate its decisions in a lot of cases. We didn't get real school desegregation, for example, out of Brown against Board of Education. We got it out of Title VI of the Civil Rights Act and the federal government starting to withhold funds or threaten to withhold funds from southern school districts. That's when we got desegregation. And now you have a president who is essentially threatening in a variety of ways not to obey the Supreme Court. And the question of what the Supreme Court will do, whether it will stand up for the law in the face of a lawless administration, is, I think, really an open question at this point. And I don't think anybody would have predicted years ago that the question of the Supreme Court standing up to the government was an open question.
Yeah, I certainly agree. Just to flag, the Humphreys executor case that Pam mentioned is called Slaughter versus Trump, and it'll ask whether Trump can fire members of independent agencies, including the FTC. I invite our other panelists to weigh in on this question of what are the vibes of the Supreme Court this term? What's the trajectory? And I'll add a little spin. Do you see any cases that give us reason for hope? We haven't talked about the tariff case. That's one area where I think it's sort of anyone's guess whether the court will rein in Trump or not. But I turn the floor over to our panelists. And Carlos, I'll start with you.
So, yeah, so I do think if the court is going to say no to the administration on an important issue of policy, it is likely to be on the tariff question, in part because the tariff question affects a lot of powerful economic sectors in the United States. And this is a court that has time and time again come to the protection of powerful economic sectors. So, but, the tariff case, even if the court says no to the administration, is only one of a multitude of disputes involving what are, in my view, unconstitutional exercises of presidential authority. And what I think is particularly problematic, to go back to Slaughter, to go back to Humphrey's estate, it's one thing, and we can have the debate, and we've been having debates and law reviews, et cetera, for years about the unitary presidency, so-called, and whether Humphrey's estate was correctly decided, right? I mean, I think we can have a rational conversation about that. But while we're having the rational conversation, right, and while the courts are deliberating, it seems to me that the court should abide by existing precedent. And Humphrey's estate is an existing precedent. Congress clearly has the constitutional authority under that state to limit the president's power to arbitrarily fire people. And what I just cannot understand, and what I think is a violation of basic legal principles, it's like law 101, right? Precedents are the law until they are overturned. And therefore, in making emergency docket decisions, the default position should be, we'll stick with the precedent, right, until we can get to the merits. But the court is doing the opposite time and time again.
I think just briefly, we're going to see more dissents by Justice Jackson. She's really distinguished herself as an outspoken, critical, and sharp dissenter. I think stats-wise, she wrote the most dissents last term. She's really hit the ground running in writing dissents. Other justices, I believe, including our Chief Justice, was much slower about authoring solo dissents. And that's another distinguishing quality about Justice Jackson and the way she dissents is that, even in a case like Estrellas, which came out at the very end of the term last term, which was about sort of the federal sentencing guidelines and the revocation of supervised release for people who have been federally convicted. And in general, the court came out on the side of the defendant there, but Justice Jackson joined Sotomayor's dissent and then authored her own. And I think she's really giving future generations, a clear roadmap for how to repair so much of the damage to basic procedural protections of criminal defendants and those accused of crimes, and then the legitimacy of the Supreme Court. I mean, some of her dissents point out the fact that the majority is bending backwards to accommodate the current administration. And so I think we'll see more of that, and not just joining dissents, but authoring them and authoring them solo.
And I'll just add here, since we all get to have crystal balls with this question, on the merits docket, the first case that I showcased, Urias Oriana, I have hope in that case. We don't know how the Supreme Court will react and behave in the wake of the demise of Chevron and wake of Loper Bright. I think I have hope that there could be a determination, especially in the wake of a significant circuit split as well, that de novo review will be the conclusion. And to go back to the case referenced by Pam, late on Friday, the Solicitor General filed a cert petition in the birthright citizenship case. Up until this point, we've been having a back and forth on the emergency docket as it relates to nationwide injunctions. But the question before the court, if it grants cert, that was placed before it on Friday, is with respect to the language of the 14th Amendment of the U.S. Constitution, which states in part that all persons born in the United States are subject to the jurisdiction thereof, right? So I have hope that a sort of more than 1 century old Supreme Court precedent and recognition of birthright citizenship could survive. Quick note on the emergency docket, I don't see that pace slowing down. We already have a second ask to the Supreme Court on the emergency docket as it relates to TPS, or temporary protected status, for certain Venezuelans. That termination was stayed earlier. We had a final decision by the district court, and we have a new ask for the court to stay it again. And there have been more losing outcomes than there have been winners, and I don't see that pace changing.
I wanted to ask one last question about the emergency docket or shadow docket before we turn to Q&A. We've talked about it quite a bit. Zanel mentioned up top, one of the consequences of the court intervening so regularly without explaining itself is that it's leaving lower courts in the lurch, leaving lower courts without any clear guidance of whether they're supposed to follow existing precedents, like Humphrey's executor, for instance, or whether they're supposed to simply guess where the current Republican-appointed supermajority is going and try to align its decisions, their decisions with that. I'm curious if anyone here thinks that the justices will hear that critique or that plea from the lower courts and try to provide more reasoning or even intervene less aggressively, or if we all think that the shadow docket is just here to stay, at least under Trump, and that the majority is not interested in explaining itself any more than it has to, and will continue to leave lower courts guessing what the state of the law is on any given day.
The latter. No, I mean, I'm serious. If you talk, as I often do, to judges on federal district courts and on courts of appeals, they are doing the best they can, and they're doing a pretty good job overall. Obviously some exceptions, but they are following the law. They are looking at the relative harms. I mean, they're using the preliminary injunction standard that and TRO standard that the Supreme Court has long required, which is you look at likelihood of success on the merits, you look at the public interest, you look at the relative balance of harms. They're following the law as it exists, and the Supreme Court is both not giving them much guidance, and then there was that kind of savage attack on Judge Young for his trying to understand what the Supreme Court was requiring him to do and what it was not requiring him to do. And I don't think the current justices on the Supreme Court are particularly interested in what lower court judges, the difficulties they face, or what they think.
I thought it was very interesting that Justice Breyer came to the defense of Judge Young. I think that was quite telling. That Justice Breyer basically came out of retirement to say, you're picking on this guy, he's doing the best that he can, and you're accusing him of things that he simply has not done. And I thought that was a kind of a powerful rebuke.
All right. Thank you. We have a few questions on the table that I'd like to get to. And I'll start with one from Jordan Reynolds now, who asks, in Childs v. Salazar, if the court rules in Child's favor, will that ruling apply to other practices of conversion therapy besides talk therapy? So will the ruling strike down other kinds of conversion therapy that go beyond pure speech?
Presumably not, right? Because in order to get through the door, in order to be able to make the argument, it's a First Amendment challenge. So it has to be speech. There has to be speech involved, and that's from the perspective of challengers like Ms. Childs. It helps her that she only engages in so-called talk therapy. I suppose there could be an argument to be made that the way in which other forms of practices of treatments, quote unquote, are applied have an expressive component to them. But my goodness, I'm hoping that we're not going to go that far. So presumably the state is, even if Colorado loses in Childs, the government will retain its police power authority to regulate conversion practices that do not involve talk therapy. So the ruling will presumably be limited to talking as a form of professional, dare I use the word, conduct. I'm sure they're not that, and that is really the big disagreement in the case, right? Do we see this as a form of professional conduct, of medical conduct, of medical treatment, in which case the state would presumably have plenary authority to regulate it, or is this protective speech? And I worry that the court will deem it to be speech, completely speech, not conduct, in the same way that it concluded in 303 created. Essentially, that the act of discrimination, of turning somebody away, that wasn't what was being regulated by the Colorado anti-discrimination law. It was the expression, the providing of the web design services in that case, which constituted speech, as, to be fair, as Colorado stipulated during the litigation.
Thank you. We have a question from Justin Wise, a Supreme Court reporter with Bloomberg Law. And he asks, how do you see the liberal minority on the court approaching the use of dissents on the emergency docket? And what effect, if any, can those dissents have on the court? And I'll just add to Justin's question, on the court and perhaps also on the public at large. Alexis, you already touched on this briefly. Do you want to, Pam, do you want to take a stab at it?
Oh, I thought you were asking if Alexis wanted to.
But then I saw your mic went off and I thought, let's get to Pam first, then Alexis.
And
so
I've
that's the
weighed
order.
in, Pam. It's all
Sure.
you.
No, go ahead, Alexis.
Oh, I mean, it's a continuation of my last comment, which is that Justice Jackson is really using her platform to dissent, to file solo dissents, author solo dissents. And it's very much, yes, for future generations of practitioners, but also all of the public. Who is concerned with the court and our laws and the rule of law. She writes them in a very accessible way. She will use common sort of phrases that we hear, more so in speech than in written legalese. And I think all of that is to communicate sort of the dire, conditions that we're under with the way that the court is deciding things.
Thank you.
Yeah, I agree with everything that Alexis said. I think, if you think back to the late Lonnie Guinier's article on demonstrudence, speaking to the people as opposed to speaking to the lawyers or to the parties of the case, I think that's where Justice Jackson is now. I don't know that dissents are really trying to move the justices inside the court. And it may be that, especially Justice Kagan, is strategically trying to decide when to dissent and when not to, based on whether she thinks it's possible to count to 5 on the merits of a case, even if not to count to 5 on the emergency stay of the case or the like. I think this is part of why some of the justices on the emergency docket don't write anything, is they don't want to lock themselves in too much too prematurely when they're doing things kind of on the fly. And that may be true also of deciding when to dissent and when not to.
And I'd love to chime in here on the segment of the question as it relates to the court of public opinion, because we are seeing the language that speaks to the people, as one just shared, also serving as an education, these dissents to the public. So okay, confession. I watched CBS this morning at 7 a.m. on some mornings, and just a week or two ago they had Justice Sonia Sotomayor on, and one of the news anchors was reading from her dissent in Vasquez Perdomo, and I think that's a good example of how these dissents are also educating the public and making them curious in some way.
I mean, and to some extent, Justice Kavanaugh's concurrence did a lot of damage. That had the majority remained silent, people would not now all be walking around saying, "You mean just being Latino and having an accent and going to Home Depot is enough to stop you?" And so I think that kind of shows the problem with these sort of off the cuff opinions is, they can strategically be useful or they can strategically be quite damaging.
Thank you. Yes, I certainly agree that Kavanaugh absolutely, though inadvertently, made a lot of trouble for himself in the court by writing that opinion. I do think that he's trying to respond to some of the criticism of the court refusing to say what it's doing and why by offering his own views. But I think that for whatever reason, he is not very adept at offering those views in a persuasive way, or perhaps the views themselves are just so often alarming that it attracts more negative attention to him and by extension to the court. I think that was the story of Vasquez Perdomo. That and his highly dubious recitation of the facts on the ground. One more question on the shadow docket, obviously a topic of great interest. So this is from Patrick Patterson, who asks about the likelihood of success on the merits standard that the court uses in the shadow docket. And he says, do you think that the Supreme Court majority is likely to say loudly and clearly that this standard does require lower courts to look at the shadow docket decisions and use those to determine likelihood of success? So in other words, is the Supreme Court going to come out and more clearly say that shadow docket decisions are in effect precedential, which would be a break from what some of the justices, including Justice Alito, have suggested in the past, which is that those decisions aren't precedent. They're just an attempt to kind of issue an interim decision while the case is still pending and they decide on the merits later. I actually think this is the question. Shobha, go ahead.
I'm not qualified to answer that question in the yes or no, but what I can share is that it would be deeply concerning if that was the direction the Supreme Court went in as it relates to direction and guidance to the lower courts. When you offered at the top of this Q&A the principle and concern that I believe we all have as it relates to the lack of guidance to lower courts with these emergency docket decisions. The solution to that question is not to standardize or transform those decisions to precedent. The solution is to have more merits docket cases and reasoned decisions and transparency with the courts and American people.
Until the Trump against Boyle case, I would have said that shadow docket decisions were not precedential. But in Trump against Boyle, the Supreme Court came pretty close, I think, to saying exactly that, which is this was a case about whether the president could fire one of the commissioners of the Consumer Product Safety Commission. And the Supreme Court granted a stay there, and what they said in the opinion is, granting the stay, said, although our interim decisions are not conclusive as to the merits, they inform how a court should exercise its equitable discretion in like cases. And that does seem a retreat from the view, which is our emergency docket cases aren't precedential. And even if you think that that was their previous way of thinking about things, I mean, if you think about the Purcell principle, which has been a fundamental piece of election law for the last decade, which is don't change the rules too close to an election. Purcell itself was an emergency docket case, and it has been turned into a precedent. And so I think it's a very permeable wall between non-precedential and precedential Supreme Court decisions now. The only place that I think we can be absolutely sure a decision is not precedential now is when they affirm something by an equally divided court. So last term, the case about charter schools in Oklahoma, we can easily say that decision to affirm the decision of the Supreme Court of Oklahoma is non-precedential.
Thank you, Pam. And on that note, we are at time. So I want to thank Interim President Zanelle October and the American Constitution Society for putting this on. Thank you to our fabulous panel for this very enlightening and illuminating, though sometimes depressing discussion. Thank you for offering glimmers of hope as well. And thank you to the audience for joining us. I hope you learned a lot, and I hope we all feel prepared, or as prepared for the term ahead as is possible. Thanks.